Welcome back, America. I'm Hugh, joined by Senator Marco Rubio, whose brand new book, Decades of Decadence, is in bookstores today, available at Amazon. I put the link over at Twitter. Senator, on page 172, you write, the divide between people who live in this country and want it to prosper and those who see the U.S. as fundamentally racist, sexist nation that must be radically changed or dismantled if it wants it to survive. That's the key difference. And you go on to expand when this difference began. I don't know how we end it. And Decades of Decadence says we've got to end it, but how do we end it?
Well, first of all, I think it's important to understand that divide. What's really important about it is that even though the group of people who believe this country is inherently evil and needs to be dismantled and restructured is small, or the minority, they're a very powerful minority. They happen to be CEOs, and they run media, and they're at the top of government agencies, and they control academia for a long time. And it really began when it was a lab leak from academia. Okay, it was a virus that existed in higher education that got outside of the lab and has now infected the population, or at least infected all of our major institutions. And I think the way we begin to stop it is standing up against it at every level. And that's why history is so important. You know, the French Revolution is a great guide. The French Revolution that began in many ways on strong principles evolved into a hysteria that they wound up running out of people to guillotine. And so that's where we're headed here as well. It's become a hysteria, and people are learning the hard way that they won't stop. There's no institution or individual, no matter how woke you are, eventually they'll come for you. Look at the other day what happened at the White House. Joe Biden decides to have this pride event, and then you've got this social media influencer, a man who's transitioned to being a woman and so forth, going topless and bragging about it. And it's an embarrassment, right? And to the country, it's distasteful, no matter who it was. So it's what happens when you begin to allow this thing to continue. It will not stop. It's a virus that will keep spreading until we stop it.
Oh,
so I think it really begins by calling it out for what it is.
Now, in Decades of Decadence, you write that we now call these things grievance studies, and we call it the successor ideology. And it all boils down to, in the term of art used by the left, opposition to Eurocentric cis-heteronormative patriarchy. Now, that does include pretty much the culture of grievance. It's absurd. I think most of America thinks it's absolutely absurd. But can the Republican Party reconstitute itself into dealing with this central ideological challenge at home while it deals with an aggressive Chinese Communist Party and General Secretary Xi abroad?
Well, and they're interrelated. I mean, just put yourself for a moment, if you can, in the position of some high-ranking official in Beijing watching what America is doing to itself. And they're thinking, look, we're just going to keep doing what we're doing. These guys are doing a great job of dismantling themselves internally. I mean, you look at the social media pages of our military. I mean, they've turned our aircraft carriers into cruise ships, where they're having, drag night and gay poetry readings. And look, I don't care what adults do. I don't care what adults decide to do in the privacy of their lives and so forth. But you can't turn our institutions into a platform for hysteria on either side. I don't think we should have heterosexual night either. Their job there is to defend us against our enemies, not focus on this lunacy. And so it just continues to spread. And you're right. I mean, it is a rejection of the following: two-parent families, and not only is it a rejection of two-parent families, of traditional marriages. This is not tolerance of alternatives to these things. It is intolerance towards anything that's traditional, that 5,500 years of culture and recorded human history have built up, that we inherit from Western civilization. And the argument that these things are not just bad, that they're evil, they're destructive, they're racist, they're bigoted, they're discriminatory. And so we've gone from an argument of tolerance to a push for intolerance against everything that basically humankind and common sense has told us works.
Senator, if we had elections on the debate about the issues at the heart of this divide, Republicans would win them all. I think Donald Trump's presence in the election is going to obscure that fundamental debate. Do you for a moment worry that the Department of Justice is incentivized to get people to look away from an open border, from transitioning children at the age of 10, from all of the lunacy, by throwing Trump into the middle of this with an indictment?
Well, I think clearly what's happened now is there are no guardrails left. If you watch basically the entire American media landscape, there is no penalty to be paid for going overboard on Donald Trump. In fact, it's celebrated, right? It's being celebrated on every network. The commentators are giddy. in some ways, I think that's a good thing, right? Because we used to pretend, okay, that journalist, they don't like us. They're probably biased, but they're fair. They'll give us a fair shot, and if the other side does something really bad, they'll report on that too. Now there's no pretending. I mean, I think that's the one thing Donald Trump has done is unmask that reality. Is that that these people are they absolutely have an agenda, and they don't feel they need to hide it. They don't feel they need to hide it. Look, the president of CNN lost his job because he hosted a town hall with the leading presidential candidate on the Republican side at the moment. I mean,
it's like Senator Cotton's op-ed in the New York Times, which you write about. A single event brings a meltdown that causes hierarchy changes.
It's unreal, and it's what we're living through. But we got to talk about it. We got to fight against it. We got to build alternatives to it. And I think eventually we win people to our side. Most Americans are not ideological. They just want to have a job, raise their families, and retire with dignity. And we need to show them the path towards that.
And that argument is in Decades of Decadence by Senator Marco Rubio. It is a bestseller. It deserves to be a bestseller. Congratulations, Senator. Unlike any book by a senator I've read before, Decades of Decadence. Thank you, Senator Rubio. Morning glory, America. Bonjour, hi, Canada. Hugh Hewitt live inside the Beltway, joined by Andrew C. McCarthy, our go-to former federal prosecutor. Good morning, Andy. Thank you for joining me.
Hugh, it's my pleasure.
Andy, there are 5 categories of people on broadcast media or in print commenting on this. Non-lawyers, and I don't care what they think. Lawyers, and I really don't care what they think. Lawyers who have worked at DOJ, I begin to pay attention. Lawyers who have worked at DOJ with security clearances, that would include me, and I pay very close attention. And then there are lawyers who have held security clearance at the highest level who've actually tried cases involving classified documents. That's the highest level of authority, and that's you, right? You've done that, and you are that.
Yeah, for better or worse.
Have you seen many other people on television commenting about this case who have actually held clearances and tried cases involving top secret documents?
A few. I thought it was interesting, Hugh, that I was on Fox for a lot of the coverage with John Turley, and I thought it was an interesting mix because I did it from the prosecution side, and he's done it a number of times from the defense side. So I thought that was pretty good coverage of how this usually pops up.
That's it. Now, I begged Andy to come on today because I have questions. And I'm one of the guys who had the highest clearances you could possibly have, but I've never tried a case like this. So I wanted to ask him these questions. First of all, at the heart of the government's case are these 31 documents. As a professional prosecutor, would you have included what Jonathan Turley calls the jump scare photos of documents full of boxes with thousands of documents when we're really talking about 31 documents?
I don't think so because, I think the point that gets pushed back on that is obviously, the subpoena or the search warrant was overbroad in a sense that they tried to criminalize the Presidential Records Act so that the National Archives, having asked for over a year for Trump to give this stuff back, they didn't really, they wouldn't have kept asking if they had a legal mechanism to get it back. So what they did was get the Justice Department to stitch onto its search warrant a general criminal statute about converting government property to one's own use, and they effectively criminalized the Presidential Records Act, even though Congress didn't put criminal provisions in it. I was not surprised to see that they did not do that in the indictment. So it seemed to me that they just wanted their stuff back. And I think they should have just left that episode as it was and stuck to the documents that make a difference in the case.
All right, those 31 documents, this is a key question for me. Do you think the jurors are going to have to actually eyeball those documents and be persuaded of their importance before they can convict on those 31 counts? Not talking about obstruction. That's pretty cut and dry, and I kind of agree with Bill Barr. It looks very bad for the former president on obstruction. But what about the 31 documents?
Well, this is the very interesting question, and it gets also to how you get this case to trial and why I don't think they could possibly get it to trial prior to the next election, or the next presidential election. In most cases, when you are dealing with classified information, you're dealing with it because of the substance of the documents. In this case, the argument by the government is going to be substance is irrelevant. and the jury doesn't need to see it, plus can't see it because it's some of the most top secret stuff that we have, because the only relevant issue in the case is the fact of the documents. That is to say that he had documents that were classified at a certain level. I think that's why there's an explicit description in the indictment with respect to each document of what its classification level was, although I think there was one document that doesn't have a classification level assigned to it, but the other 30 do. I think what they're going to try to argue is that it doesn't matter what's in the documents. In this case, what matters is that he had the documents and they weren't authorized to be in that place. What Trump is going to push back and say, as defendants typically do in these cases, is that he can't really make his defense unless the jury can get a look at the documents or parts of the documents, or more of this is the important part, more of the documents than the government wants to show. And the reason they do that is what we call the classic gray mail situation. It's not going to be that the defense thinks that the substance of the documents is exculpatory. They're going to think that the government doesn't want anyone to see the documents, and that puts the government in the position of cutting off the defense's ability to make what they say is their defense, which is the way people get convictions reversed. So that's where this gets fought out.
Does that question get decided before they begin to seat a jury? In other words, do the Trump lawyers go in and say, Judge, make a ruling right now that the jury is going to see these documents because the government has put all the weight on these documents? They've convinced the country that Trump put us at risk. They're going to have to prove the documents put the country at risk. Not that the classification existed, but that the documents themselves were dangerous. Does that get argued and decided before the trial begins?
Yes, and this is the reason why I don't think they can get the case to trial. So when you are in a situation like this, what applies is what's known as CIPA, the Classified Information Procedures Act. And it's a kind of I always thought of it, Hugh, as like a pretrial trial of the trial, in the sense that the regular rules of evidence apply. So, you don't get a heightened standard of relevance and probative value just because you're dealing with classified information. It's the regular rules apply. But what happens is the government says what classified information it intends to offer in the trial. The defense, after getting discovery, tells the court what classified evidence it intends to introduce in order to make its defense. And then what has to happen is the court has to rule, especially if the government objects, which it typically does, to how much the defense wants to put in. The court has to rule on what's relevant and admissible on the regular standards of evidence. And at that point, if the court says that there has to be classified information introduced at the trial because it's relevant and it helps the defense make its defense, then the government has a choice to make. Usually the first round is you try to propose a substitution, which gives the defense the information that they need to make their arguments to the jury, but they withhold the actual classified information. Often the judge will say that's not good enough. They have to get the information. And then the way the law works is the Justice Department and the executive branch are supreme in the area of classified information. The judge is supreme as to the litigation. So what happens is the attorney general can order the judge not to allow certain documents to come into the case. The judge then can say, okay, fine, but then these counts have to be dismissed, or perhaps even the whole indictment has to be dismissed because the defense can't get a fair trial without, this information. That takes a long time to play out. Just to give you a quick sense of this, in the Blind Sheikh case, for example, we had an issue about Pakistan acting as our cutout in Afghanistan when we were supporting the Mujahideen during the war against the Soviets. I can talk about this now because it got declassified during the 9/11 Commission hearings, but I wasn't allowed to talk about it before that. But we had an 18-month litigation, and I think By the time we finally got to trial, I read a 9-line stipulation to the jury about what the role of Pakistan was.
And by the way, Andy, you had clearances. Did the defense attorneys get clearances? Will all, if these documents are successfully entered into the case as necessary by Team Trump, does every juror need a full field background investigation? Every alternative juror? Do we need skiffs all over the place? You've been there. Tell me.
Yeah, you're not going to need clearance for the jury, more than likely. I've never heard of a case where that had to happen because they will figure out what will happen. Is the evidence that ultimately comes into the trial is going to be declassified. The question in the SEPA question is what evidence is going to be declassified. In other words, when the defense says we need this classified information to make our defense, the government can do one of two things. I mentioned propose a substitution. The other obvious thing it can do is just declassify it. But one way or the other, the evidence that comes in at the trial is going to be public.
When I come back with Andy, that music means I'm going to go to break. I'm going to talk to Andy during the break, put it on the podcast, play it for you an hour or three, and then we'll be back live with Andy. What a surprise. You haven't heard these questions asked because most of the cable media doesn't really want to tell you how long this is going to take, and it's going to take a long time. Stay tuned, America. I'm Hugh Hewitt. Welcome back, America. Hugh Hewitt talking to Andrew McCarthy. Andy, do Trump's lawyers, every member of his legal team, need a security clearance?
Not every member of the team, but any member of the team who's going to be involved in classified information litigation. Remember, again, once the stuff gets into the courtroom, it's either going to be declassified information or a substitute. So that will be public.
Yeah, I've got a very practical issue, though. If he adds some lawyers now to his team, and they've been in the China office of White and Case or wherever, they're going to have to clear those people, right? Or they're not going to be able to review the documents and make the arguments that we've been talking about.
Yeah, I think it would be very impractical for him to take on lawyers who can't get security clearances. They have to as a practical matter, you're right, they have to.
And so he's entitled to choose his lawyers. So if he chooses lawyers for whom clearances are hard to obtain, it's going to delay the case, right?
Well, he's allowed to choose his own lawyer within reason. I mean, the constitutional right is that you have a right to counsel. Presumptively, you have a right to counsel of your choice. But if you choose counsel that can't serve on the case because of a conflict or some other reason, you don't have a right to that. So he can't delay things by trying to get counsel that can't get cleared.
But they don't assume he just picks some lawyers. Go ahead.
I was going to say the government can't unreasonably delay things by denying clearance to people who should get it. So that's the rule of reason that applies here.
All right. Now, if the RNC lays out its full debate schedule, first one's in August, we expect one a month, we expect more in January, February, the primaries start in January. Will the judge take into consideration that the election is underway and just simply declare up front, we're not doing this till 2025?
That could happen, Hugh, but, if I'm the judge, I have to factor in the fact that this is not the only thing on Trump's dance card, right? So, he's got the Manhattan trial, which is now scheduled for March 25th, which I think is 2 weeks after Super Tuesday. But even before we get that, we're going to get indictments probably in Georgia, first or second week of August. He is scheduled, a lot of people are not focused enough on this. I think this could be a big deal, but on October 3rd, the trial in New York of the civil fraud case that was brought by Letitia James, the Attorney General in New York, that's supposed to start. That trial's going to take a few weeks. And as we saw with his E. Jean Carroll case, being the defendant in a civil case where you're expected to testify and they can comment if you don't testify, that's a big problem. It's not an easy thing to navigate.
This is a nightmare. Now, this is the key question. Most people are arguing either about how bad it was or how bad the double standard is. I'm trying to talk both. Is the standard applied to Trump to charge the same one that the Department of Justice is obliged to use vis-a-vis President Biden's garage documents? Because while the obstruction isn't there, and correct me if I'm wrong, giving the documents over doesn't do anything to the counts that would be Espionage Act relevant and equal. It's just that Biden didn't obstruct once he was discovered. So the 31 depends on the documents he had, right?
Yeah, the crime is complete when he retains documents in a place where they're not supposed to be or handles them in some way that's reckless. So what he does after that to obstruct or not obstruct is irrelevant to whether the crimes got committed or not.
And so if Hur uses the same standard as Smith, do you expect President Biden to be indicted?
I don't. I think he should be indicted, by the way, but I don't. And I think the reason for that is it has seemed to me from the beginning, Hugh, that they're trying to draw a distinction that Trump's conduct was willful, and they want to suggest that Biden's was inadvertent, more like the Hillary Clinton standard that they invented for that case, which was that, she was careless, but somehow not so reckless that she should have been charged. And I don't buy it. We don't know enough about the Biden case yet, but if he had documents that were from his time in the Senate, senators don't get to take classified information home. So it seems to me if he had that stuff, it was willful.
It's the same crime in my view. Now, Andy, key question
agree.
here. When is your best guess on when the trial of the federal side, the earliest it could begin?
If the trial happens, it would be in 2025 sometime.
All right.
I think obviously the way this is teeing up, if a Republican wins the election, it's unlikely the trial will happen.
So isn't justice supposed to stay out of politics? I do not understand why Merrick Garland greenlighted this.
Yeah, well, I think justice, it's a very tough question, Hugh, because being a candidate for office cannot be immunity from prosecution for serious crimes. But at the same time, it's killing this country to have every single election cycle the Justice Department and the FBI in the middle of our electoral politics. It's just destroying the country.
Yeah, it's the third time in a row. Now, Andy, last question. You may go into the break, and I'll put it on. In terms of the president's defense that he declassified the documents, I'm not saying it has merit, but how does he get that into the record without appearing as a witness?
There would have to be. This is why I don't think he has a defense, Hugh. First of all, I think if you do that under the Presidential Records Act, there should be a document supporting it. Otherwise, he's got to have a witness that shows that he did it. I don't think he has that. And I also think it's irrelevant because it's not a defense to these charges.
But assuming he thinks it's a relevant argument and they want to make the argument to the jury, how do they even get the assertion that he declassified them in his mind into the record without him going on the stand? Go ahead. We can talk through the music.
Yeah, I don't see how he could do that. He's got to, if it's the operation of his mind, he's got to testify to it.
That's what I thought. All right. Andy, you're wonderful. Keep coming back. Hi, America. Bonjour. Hi, Canada. Hugh Hewitt live inside the Beltway. Headed back north tomorrow, but I'm happy to talk with Bret Baier of Fox News Special Report to start off the day. Good morning, Bret. How are you?
Morning, Hugh.
I believe that the coverage of the Trump trial and the proceedings prior to it will present one of the most difficult news challenges that I can remember. What do you think?
Well, I agree. I think it's fraught with all kinds of things that potentially are missteps in the middle of an election. I mean, he is the leading GOP frontrunner by a lot. And, how you cover it, when you cover it, how much coverage you give it is, these are all news challenges that you have to do. I'll talk to him in Bedminster on Monday and, get a sense of some of the questions that I think people want to know the answers to.
Now, how long are you going to get to sit down with the former president, Bret?
1 hour.
1 hour. And so will his lawyers be in the room?
I don't know. It's been a while, but I don't know. I've talked to the people. We've worked the logistics. There are no stipulations. There are no restrictions on questions. It's 1 hour. If we cut it, it'll be for time, but not substance. And we'll probably split it over 2 nights. But those are the only things I know.
Well, what a blockbuster. And that's on Monday?
It is Monday. I go to Bedminster. It'll be probably mid-afternoon, and then I'll front the show from New York.
Okay, now, if I were king of the forest, not queen, not duke, not earl, I would ask him about his legal team and whether they've got clearances. I just spent a half hour with Andrew McCarthy, who is in my category of the people you really want to talk to about a case like this involving classified documents. He thinks it's going to take forever to get to trial. Do you agree with that, Bret?
I think so. I mean, you think about the pretrial motions that you've got to go through already. I mean, the challenges. We know that they're going to challenge the search warrant of Mar-a-Lago. We know that they're going to challenge the questioning of one of the Trump attorneys, who is attorney number one in the indictment. We know, there are a number of different pretrial motions that you're going to have to get through, let alone the legal team that is cleared to deal with classified material.
Yeah, the obstruction matter is the easiest one to prove against him. I think Attorney General Barr, when he was talking with Shannon Bream on the weekend, made that pretty clear, that the obstruction doesn't require access to the documents. It requires proof of the subpoena and its rightful issuance and proof that he obstructed compliance with it. But the 31 documents are at the heart of this case. And Bret, if the jury doesn't see the 31 documents, I mean the real documents, do you expect them to convict the former president of the United States on the expert testimony of the Bureau that they're important and they compromise the security of the United States?
I think it's tough. I think the special counsel has to get all of the jurors. He has to be across the board, obviously, to convince them all. I think it's tough to imagine that there's not one juror who says, wait a second, I didn't see that. I don't know that that's the case. And they've been going after Trump since the beginning of the time of his time. So, I think it's a tough bar to get over.
And so I talked about this with Andy. There's a Classified Information Act about declassifying and whether or not the Department of Justice says, no, you can't use it, and the court saying, well, then you can't use it. It will go on forever, as will his assertion of privilege about declassifying. And I think these are interlocutory appeals. So does Andy. Have you heard anyone talking about just the logistics of this? Because you're going to be conducting the first debate, and this will have not moved an inch. So the question is really going to be, what are you going to do about this in the first debate, maybe the first two debates?
Yeah, I agree with you. It's obviously got to be a part of it, and I think that some of these candidates that are opposing Trump are going to run on, we need to move on from the chaos as part of their message. But I agree with you, and he's going to use it as this is political, jumping on and to fire up the base that there's a reason why they're trying to keep me out of the White House again. So it'll be definitely a part of the campaign. The other thing you have to think about, Hugh, is that other cases may drop in that time. Georgia is expected to come back in, late summer. And January 6th, we haven't even talked about, which is the special counsel's second effort.
Yeah, Bret, I am amazed that they've done this, but I want to talk to you about covering it. There are a bunch of people who want to comment. There are non-lawyers. I don't listen to them. They want to come on your show and talk. Forget it. Lawyers, they're a dime a dozen. Doesn't mean they know anything. Lawyers with DOJ experience, okay, I begin to listen. Lawyers with DOJ experience who had the highest clearances, that would include me, I begin to listen more closely, Attorney General Barr. And then there are lawyers with DOJ experience who actually have tried these cases, like Andrew McCarthy, who know what they're talking about. When you are lining up guests to opine on this, are you looking for people in the last category?
Ideally. I mean, it's a pretty small bunch, as you know. I think there are people like Jonathan Turley who really have value and expertise. I think Andy does as well. It's interesting to listen to somebody like Mark Levin, who takes an exact opposite position. But he also, knows the law. So, yes, I'm looking for expertise.
And Mark has DOJ experience, and he had the same FISA clearances I had. So he's actually seen material like this. And I can't imagine convicting the former president unless the jurors see those documents and believe they are dangerous. Because, I don't trust the DOJ here, Bret, to have described the documents correctly.
I agree with you, and I think that I do think that this is a part of a bigger effort by the special counsel, and And I don't know whether this is leading up to a January 6th, seditious conspiracy effort, but it seems like it's one rung on the ladder in what they're thinking about.
Let me switch over to the president, President Biden. Andy just said the crime is complete when you remove a classified document from the SCIF. We've got classified documents at Team Biden. They didn't obstruct, all right, so we're not going to get an obstruction count against them. But do you expect her to use the same standard that Smith did in charging the president as Smith did the former president?
I mean, you would think, right? But I don't know that that's what we're going to see. And I think there is a real question here about, how this is being dealt with. Listen, those documents were handled. They were split from boxes. They were in different places. There is intent to at least separate them in different places. And whether they're accessible to people and whether people had, saw them, if there's some way that they can prove that documents were seen by other people, I think there's a problem there too.
Oh, it's very complicated. It should be one standard. Let me close by talking about the Cruz interchange with the assistant director of the FBI 2 days ago. Senator Cruz could not get him to answer whether the 17 tapes even exist. Do you think the FBI has to answer that question on the existence of the tapes, Bret?
Yes, or they have to. Yes, I think they do. And, we have no transparency into what has been happening in Delaware in this investigation, 5+ years. And you heard Bill Barr on the show last night, on my show, say he's extremely troubled. It was 2 years when he left, 2.5 since he's left. And he thinks he doesn't understand why that hasn't moved forward unless there's a problem here.
Well, there is a impeachment of President Nixon that involved tapes, and Alexander Butterfield just answered the question. Yeah, there are tapes. The former president, released the tape of his call with Zelensky when it became controversy, and now we have tapes again. Tapes are always like the number one thing, and for the FBI not to answer whether they exist. By the way, they're not probative. They don't. You can get anyone calling from Ukraine saying, I'm a Burisma's board and I paid Joe Biden $5 million. Doesn't matter. It's not dispositive. But we need to know whether such tapes exist. Do you expect that eventually Ray will answer that answer?
Has to, I think. And you look at what happened with the 1023, that it didn't exist. They didn't have it. You can't have it. Okay, you can have it redacted. Okay, let's talk about it. I mean, there's been an evolution here. And I think you have to answer the question about the tapes.
I think you're exactly right. Bret Baier, good luck on Monday. I know you're going to be cramming all weekend long. We'll all be watching, and I envy you the opportunity, but good luck because it's only an hour. It takes a while to get anywhere with President Trump in an hour. But
that's true.
Good luck on that one. I'll be right back, America. Don't go anywhere. I'm broadcasting from D.C., and I do believe we've reached the end of the road of commentary on the Trump indictment. I'll talk to Marco Rubio about it. Because nobody knows anything, to quote William Goldman, the screenwriter, famously remarking on which movies will succeed at the box office. Nobody knows anything about when this, quote, trial will begin, or even if it will begin. And Merrick Garland had better stand up and answer some questions. I'll be right back, America. Stay tuned to the Hugh Hewitt Show. Welcome back, America. Hugh Hewitt, joined by former United States Senator Jim Talent of the Bipartisan Policy Center. Good morning, Jim. How are you?
Doing very well, Hugh. Thank you.
Now, when I had Andrew McCarthy on, I said there are 5 kinds of people commenting on the Trump case. You're going to make me add a 6th category. There are non-lawyers. I'm not interested in their opinion. There are lawyers, and I'm really not interested in their opinion because they don't know about this sort of case. There are lawyers who've been at the Department of Justice, and they're different. They've got more authority. There are lawyers who've been at DOJ with the highest levels of clearance who did counterintelligence stuff. That's me. And then there are lawyers who worked at DOJ who prosecuted classified document cases. That's Andy. And then there are former senators who had the highest clearances, who have been in intelligence business, and that's you. How long do you think this trial is going to take to get started, much less to conclude?
I think a very long time. I think, as Andy explained, the nature of the issues mean that even if there were no politics behind it, it would take a long time. I don't understand the issues. You understand better than I do, and you said you don't understand them that well because neither one of us have tried cases like this. But I do get the politics behind this. And the Democrats believe that if this election cycle is about Joe Biden and his record, they very probably lose, and they might lose very big. If they can make it about Trump, based on what happened in 2018, 20, and 22, they have a much better chance of winning. And so, therefore, they have no incentive politically to wrap this up quickly, and it would be difficult to do it legally anyway. And so I do expect it to be drawn out through the whole cycle, yes.
So, Jim, this is the third cycle in a row in which the DOJ, the FBI, and the, quote, intelligence community have inserted themselves into the most important election in the world. Does no one think about that? Merrick Garland yesterday just said, well, no one's going to comment on. No one gets to ask questions about the wisdom of this?
Well, they're thinking about it in the House of Representatives, as you know, because you've had on members from the Weaponization Committee. And not only are they inserting themselves into these elections, they're inserting themselves into the elections at the same time as their credibility. Their reputation for equal-handed and fair justice is crumbling across the political spectrum. And it's a very, very bad thing, apart from the issues in this election. So we need a real house cleaning. I will say, I was looking at DeSantis's Twitter the other day, or his War Room Twitter, and they have a plan. I made a note to read it, to clean up the Department of Justice. And that's what we need, a plan, because it's not going to be as simple as It's not going to be as simple as going in there and appointing a different attorney general. It's going to take a major effort over time.
Did you hear the exchange between Senator Cruz and the assistant director of the FBI over the alleged existence of 17 tapes, 2 of which involved the president talking with Burisma executives? And we don't know that they exist, but the FBI wouldn't answer the question.
No, they're just stonewalling. And again, I don't have a leg to stand on. The same fellow you just had on, Andy McCarthy's written a number of good columns about that, and I know that, as a former member. They don't have any basis for withholding that information from the Congress. The Congress is entitled, in fact, it's the Congress's duty to oversee what they're doing, and they have to give this kind of information to the Congress. And he's just refusing to do it. Now, he may face a contempt citation at some point, but as you know, that has to be enforced, doesn't it? And who enforces it?
Eric Holder got a contempt citation, and he never got enforced. So, Senator Talent, we've had Nixon impeached over tapes. We had Donald Trump impeached over tapes, the tape of the Burisma call, the original call with Zelensky. There's an allegation that there are tapes about the president. I don't know if it's true, but doesn't someone have to tell us whether they exist, even if they don't want to tell us what is in them?
I think they'll eventually, if they keep pushing just the sheer pressure of it, they'll probably find out, or they'll get even more whistleblowers. Because as you know, there's so many good people in these agencies that are appalled at what's happening. I can well believe the whistleblowers are coming forward to you. So, yeah, I think at some point we'll probably know. But even again here, if you look at the politics of this, I think the Democrats would prefer, in terms of what the average voter's concerned about, to be talking about these issues than about the border or crime or inflation or education. See, that's in terms of 2000.
Except for the Biden documents. That's
right,
where.
I agree about that.
Do you expect her to use the same standard that Smith did? Because as Andy said, the crime is complete once you find the document in the wrong place. If there's a crime, the crime is complete. So Biden did, and it doesn't matter. You don't get obstruction charges if you cooperate. But do you expect Biden to be charged?
I'd bet good American money he won't be. Not until there's a Republican president. And
I don't want him charged. I don't want him charged. Last comment to you, Jim.
We need to fix the Justice Department. We need to come forward with an equal standard for prosecution in these cases, okay? And then we need to make the judgment based on that standard of law. So we try and rebuild the credibility of federal law enforcement and the Department of Justice. And so I don't know how that's. What I want is somebody running the Justice Department I can have some reason to trust. And right now,
Jim Talent would be a good attorney general. Jim, good to talk to you, Senator. Always a pleasure. We do need someone up there who will answer questions about why now, why not last May, why not last August, why not now. Jim Talon, always a pleasure. Stay tuned to